You thought you were choosing the higher road by steering clear of the courtroom. No bitter cross exams, no strangers poking through your bank statements, no $1,000 motions filed just to score points. Friends nodded in approval. Stay out of court, man. It's cheaper, cleaner, less toxic. The mediator smiled. Your ex seemed reasonable, and you pictured a quick signature followed by the sweet silence of moving on. But 12 months later, you're scrolling through bank alerts while your phone lights up with missed visit excuses, and it hits you. Every penny you saved on legal fees is now leaking in places you can't plug. The temporary parenting schedule she promised to honor evaporated the moment she found a new apartment across town. The cash-only support you handed over to keep things simple, the court calls it a gift, and now you owe arrears plus interest. That private agreement about bonuses? Her lawyer just discovered your end-of-year payout and wants half retroactively. And when you finally ask law enforcement to help enforce pickup time, the officer shrugs. There's no court order, nothing to enforce. You avoided conflict, sure, but you also avoided the very mechanism designed to lock fairness into something stronger than goodwill. Court isn't always a battlefield. Sometimes it's the ballast that keeps the ship from capsizing when moods change and new partners appear. Skip it blindly, and you'll learn the hardest truth in family law. A deal without a gavel behind it is just a hope wearing a smile. And hope can't garnish wages, restore weekends, or retrieve missing dollars once they're already gone. The feel-good phrase that kicks off most low-conflict splits is, "We'll just work it out ourselves." It sounds enlightened, two adults bypassing lawyers to draft their own roadmap over coffee. At first, it even works. You swap weekends without drama, split daycare invoices by Venmo, and text each other soccer schedules like teammates instead of exes. The problem surfaces when life inevitably changes. She lands a job with night shifts, you start dating someone new, or the kids hit middle school and despise overnight backpacks. Suddenly, that friendly handshake depends on two people whose priorities just diverged. Without a filed stipulation or a judge's signature, every agreement is a gentleman's promise, revocable the moment one party sees an advantage. You can't cite a text thread in court and expect enforcement. Judges need signed orders, not screenshots of smiley face emojis underlining goodwill. Worse, informal deals breed selective memory. You recall splitting summer camp 50-50. She recalls you offering to cover extras. Months later, when a ledger doesn't balance, resentment mutates into retroactive math. She tallies unreimbursed expenses and hands you a four-figure invoice backed by nothing more than assertion. Try refusing, and you're the unreasonable parent. Try paying, and you reinforce the myth that loose verbal arrangements suffice. The real cost appears when you finally petition for clarification, filing fees, service fees, duplicate attorney hours, just to codify what you should have nailed down on day one. Meanwhile, every unfiled month becomes evidence of a status quo the court is reluctant to disrupt. Your initial civility morphs into legal quicksand. The more you honor it, the deeper you sink, until the only escape is formal litigation you swore you'd avoid. This time with a weaker bargaining position because the judge sees a year of precedent you unknowingly set by trusting a smile over a stamped order. The next pitfall wears a badge of neutrality: mediation. On paper, a mediator is the balanced voice guiding both sides toward compromise. In reality, the process is only as fair as the power you bring into the room. If she controls the house, the kids' schedules, and the files, mediation without muscle tilts before the first handshake. Remember, a mediator isn't a judge. They can't subpoena hidden accounts, compel document production, or penalize stonewalling. Their job is to secure a signature, not to guarantee equity, and closing a file quickly is the metric that makes their referral list grow. So when her attorney arrives armed with complete financials and you show up still waiting on last year's tax transcript, the mediator nudges a deal anyway. Let's just plug in estimated numbers for now. Those estimates harden into the draft settlement that becomes your reference point forever. Ask for more discovery and you're labeled combative. Agree to guesswork and you bake uncertainty into the foundation of your future. Meanwhile, emotional persuasion replaces evidentiary weight. She tears up, describing the children's bedtime routine, and the mediator suggests they remain primarily with her for stability. Code for surrendering half your custodial rights before a judge even hears evidence. You push back, and the mediator pivots to cost fear. Litigation could run another $20,000. Are you prepared for that? It sounds like prudence, but it's a pressure tactic masking the one cost nobody mentions: the lifelong price of a lopsided decree. Once you sign, courts assume informed consent. Discovering a hidden bonus later doesn't reopen a settlement reached voluntarily. The antidote is leverage. Subpoena bank and employment records before mediation. Conduct a preliminary deposition if necessary, and walk in with a draft parenting plan that demonstrates structure, not emotion. When a mediator tries to split the middle, you counter with documented facts, not feelings, and a willingness to adjourn rather than cave. Mediation with muscle can save money. Mediation without it can cost everything you hope to preserve. Discovery is the flashlight that exposes every corner of marital finances. Yet it's the step most men skip when they're desperate to keep things amicable. Formal discovery, interrogatories, document requests, depositions, sounds confrontational and, yes, expensive, but bypassing it is like buying a used car without ever lifting the hood. You rely on her voluntary disclosures, a spreadsheet she swears is complete, and the assurance that we were always transparent. Meanwhile, assets are already on the move. She refinances the SUV in her name, pulling out cash that never touches a joint account. She opens a new credit card at her sister's address and funnels household expenses there, padding future claims of need. Crypto transfers hop between wallets faster than subpoena servers can blink. Without discovery, none of it surfaces until long after the ink dries, and by then the trail is cold or prohibitively expensive to chase. Formal discovery isn't about distrust, it's about verification. A subpoena to her employer reveals deferred comp statements HR would never hand over voluntarily. Bank subpoenas capture those Zelle transfers to mom, who just happened to front the down payment on her new condo. Deposing the family accountant locks in testimony about prior year cash infusions that propped up her low salary. Yes, discovery can feel invasive, but the process is mutual. You'll disclose, she'll disclose, and the court gets a full picture instead of a curated vignette. Skipping it hands her attorney a strategic gift: plausible deniability. We produced everything he asked for becomes the refrain, and without formal requests in the file, the judge believes them. Worse, any hidden asset uncovered post-decree triggers a costly fraud action, an entirely new lawsuit with a higher burden of proof and no guarantee the money is still there. Protect yourself early. Issue interrogatories within 30 days of filing. Demand electronic statements in native format, so metadata timestamps transfers, and depose at least one third-party professional, banker, accountant, or financial planner. Discovery is the only moment the rules require transparency. Squander it, and you'll spend the next decade wondering which line item in her mysterious budget is funded by money you never knew existed. Temporary orders are the scaffolding on which the entire final decree is built, yet men who want to avoid court routinely waive the first hearing or sign whatever draft her attorney emails over. They tell themselves it's just a placeholder, something to keep the peace until big-picture negotiations wrap. But in family law, a placeholder is a precedent. Judges love continuity. Once children settle into a schedule, once support starts flowing, once one parent pays the mortgage while the other lives in the house, the court labels that set up the status quo. And status quo becomes sacred. A father who skipped the temporary orders fight wakes up months later to discover that the provisional plan has quietly hardened into the default benchmark. She has primary physical custody because that's how it's been. Support payments stay at the initial emergency figure because the family is functioning, and the house remains hers because uprooting the children now would harm stability. Your chance to influence those variables was the day temporary orders were drafted, not a final trial, where you'll be arguing against a routine the judge himself authorized. Even worse, avoiding the hearing hand or instant leverage. She can claim you abandoned day-to-day parenting by not showing up to propose equal time. Her lawyer submits a one-sided affidavit. Dad sees kids every other weekend because the temporary schedule says so, and clearly prioritizes work since he agreed to cover 80% of expenses. In reality, you agreed because you thought it was short-term triage. Courts don't decode intentions. They record patterns. To stop the cement from drying, challenge temporary orders immediately. File a counter motion demanding equal overnights, balanced expense sharing, and explicit language freezing significant asset moves. If the court insists on a swift ruling, request a review hearing in 30 days, on the record, so adjustments aren't seen as disruptions, but as built-in recalibrations. Treat every temporary clause like it will be engraved in stone, because 9 times out of 10, that's exactly what happens while you're waiting for the real fight to begin. Cash feels kind when everyone's still on speaking terms. You slip her a Venmo for groceries, hand over a few hundred at pickup for the kids' new cleats, cover the orthodontist bill before insurance reimburses. You even keep an Excel sheet telling yourself it proves you've been more than generous. But without a stamped court order, the legal system views every one of those payments as a voluntary gift, not child or spousal support. Fast forward to the day negotiations sour or a county clerk finally inputs your case into the state guideline calculator. The court backdates its numbers to the date of separation and discovers you're in arrears by thousands, because none of your off-the-record transfers count. Worse, interest starts accruing at statutory rates that dwarf market returns, and some jurisdictions tack on enforcement penalties that can trigger wage garnishment, tax refund interception, even driver's license suspension. Try arguing that you paid in cash, and you'll be asked for canceled checks or notarized receipts. As if your ex will now obligingly validate money she can double collect. Even your tidy spreadsheet is suspect. Anyone can type numbers. I've seen fathers owe $20,000 in unpaid support right after draining the same amount on unofficial help. The fix is painfully simple. The minute you separate, funnel every support dollar through traceable channels that reference child support or spousal maintenance in the memo, and still petition for a temporary support order so the court ledger matches reality. If she balks at formalizing payments, let's not involve lawyers, hear alarm bells. Informal deals help only the person who plans to rewrite history later. File a stipulated order, even if the figure mirrors what you're already paying. That single sheet of paper transforms generosity into compliance and blocks future claims that you were a deadbeat while actually acting like a safety net. Because in family court, no good deed goes unpunished unless it's documented, time-stamped, and court-approved. A verbal parenting plan works, right up until it doesn't. Maybe the first few months run smoothly. You trade weekends without fuss, switch Tuesdays for a family wedding, and text each other when school events pop up. But the moment a new romantic partner enters the picture, or a work promotion shifts someone's availability, the handshake morphs into a standoff. She decides the kids should spend Thanksgiving with her because they've always done it that way. Never mind that you drove 4 hours last year so they could wake up at grandma's. Or she unilaterally signs them up for Saturday swim meets that collide with your courtside basketball routine. When you push back, she plays the trump card. Show me the order. Without a court-backed schedule, law enforcement won't intervene, school administrators default to the parent on a registration form, and medical providers follow the adult who shows up with insurance cards. Even worse, any pattern that forms during this informal phase can become the de facto status quo if the dispute escalates to court. A judge confronted with 6 months of lopsided overnights may decide the children have adjusted, effectively rewarding her for skirting agreement. Prevention is procedural. Draft a detailed parenting plan, holidays, right of first refusal, communication rules, and file it as a consent order the moment you separate. Include geographic restrictions so she can't relocate for opportunity without judicial review, and a dispute resolution clause mandating mediation before unilateral changes. Attach a shared Google Calendar to the order, making every deviation time-stamped evidence. Finally, request a police assist provision. It doesn't turn officers into babysitters, but it gives them authority to document non-compliance. Gold in any contempt motion. A court stamp plan isn't just protection against bad faith. It's the operating manual everyone must follow, leaving less room for memory lapses and new partner disruptions. Skip it, and every pickup becomes a negotiation you're guaranteed to lose the moment her priorities evolve. The final trap is often hidden in the fine print of a collaborative law, agreement, or private arbitration clause, language that proudly proclaims binding and non-appealable. At first glance, it sounds efficient. Skip the crowded docket, hire a retired judge, sign a settlement that becomes rock solid the instant the gavel in that conference room comes down. Your lawyer touts the speed. Her lawyer praises the privacy. But locking out the courthouse locks out your safety net. Courts exist not only to decide disputes, but to correct unfair ones. When you waive judicial review, you surrender the right to appeal misapplied law, miscalculated support, or newly discovered assets that the arbitrator ignored or never saw because discovery was streamlined. 6 months later, you learn she understated her stock option value by $500,000, or that the vocational expert lowballed her earning capacity. Too bad. The word binding means you're stuck unless you can prove outright fraud, a threshold so high most appellate courts won't touch it. Worse, some collaborative agreements force you to fire your entire legal team if negotiations collapse. An ethical rule designed to encourage settlement, but leveraged as a weapon when talks stall. Your ex drags her feet, your costs soar, you contemplate litigation, only to learn you'll have to start from scratch with new counsel, new retainers, and a knowledge gap that cripples momentum. The fix? Retain court oversight as the ultimate backstop. If you enter arbitration, insist on a clause allowing judicial modification for material misrepresentation or significant post-award discoveries. Refuse collaborative contracts that mandate attorney withdrawal. Keep the option to litigate with the team that knows your case. And never waive the right to appeal egregious legal error. Fast resolutions look enticing when you're exhausted, but binding can turn a temporary compromise into a lifelong sentence. One the real court system is then barred from correcting. Cutting legal corners feels like thrift. Skip discovery, bypass experts, avoid court fees. Every savings line you strike from the spreadsheet looks like victory when you're staring at dwindling bank balances and nightly Google searches for average divorce cost. But the illusion shatters once those unspent dollars return disguised as losses. Undervalued assets, inflated support, and perpetual enforcement skirmishes that bleed you well beyond what a thorough court process would have cost up front. Mediation fees might total $5,000, but if the deal lets her relocate and you spend $10,000 in airfare over the next 3 years just to see your kids, was it cheaper? Skipping a pension valuation could save you the actuary's $800 invoice, but conceding a lifetime monthly payout worth hundreds of thousands annihilates that bargain. Declining to depose her new boyfriend because the court reporter wanted $1,500, now his loan to cover her lawyer fees morphs into evidence you can't access, and the judge presumes you're the only financial heavy. Even the psychological toll has a price tag. Years of co-parenting conflict springing from a vague custody clause translate into missed workdays, therapy sessions, and a constant hum of stress eroding productivity. Legal shortcuts purchase immediate relief on credit. Interest compounding and hidden costs that surface after the ink dries. True economy is strategic spending. Pay a forensic accountant once to prevent a six-figure asset from vanishing. Invest in a solid QDRO to avoid future tax traps. Fund a well-drafted parenting plan that saves endless court trips later. A competent litigator costs less than living with a flawed decree, and court scrutiny, though expensive, often forces transparency that stops much larger leaks. So when someone says, "Let's keep lawyers out and save money," translate it, "Let's skip due diligence and hope goodwill lasts forever." In divorce, hope is the costliest budget line of all, because once reality sends the bill, the court you dodged is the only place left to appeal at double the price and half the leverage you once had. Avoiding court can feel virtuous, like sidestepping a mudslinging arena in favor of goodwill and adulting. But goodwill fades, circumstances evolve, and vague promises crumble faster than a paper umbrella in a thunderstorm. When you forego formal orders, you sacrifice enforceability. When you skip discovery, you sacrifice knowledge. When you chase bargain bin mediation without leverage, you sacrifice balance. When you waive judicial review, you sacrifice every safety valve built into the legal system. Each shortcut trades a concrete protection for the hope that everyone will stay honest, stable, and accommodating. Conditions marriage itself couldn't guarantee. The real cost of dodging the courthouse isn't the money you saved on filing fees. It's the equity you gave away because no actuary valued your pension. It's the 6 holidays you'll never spend with your kids because a handshake schedule dissolved under new boyfriend influence. It's the double child support you now owe because those cash payments weren't official. The airline miles that vanished. The crypto wallet that resurfaced after the decree. The lifetime alimony locked by a binding agreement you can't appeal. Add the emotional interest. Sleep lost, opportunities declined, peace of mind eroded, and the tab dwarfs any attorney retainer. Court is not the enemy. Chaos is. Judges, subpoenas, sworn financial affidavits, enforceable parenting plans. These aren't weapons so much as guardrails. They keep shifting stories from rewriting your future and turn private promises into public obligations. So before you celebrate a quick, lawyer-light settlement, calculate what unverified assets, unfiled orders, and unenforceable deals might cost over the next decade. Spend strategically now on discovery, expert valuations, tightly drafted orders. So the next chapter of your life isn't financed by regrets you could have prevented with one stamped document. In family law, you either pay for clarity up front or pay for its absence forever. Choose the invoice you can control.